Welcome to Study Session 2, Nigerian Labor Law. Introduction. Where there is no law, there is no transgression. Romans 4, verse 15. According to this statement taken from the Bible, where there are no rules, there can be no offense. In other words, where there are no norms of behavior, then anything goes. The Nigerian labor law, which is that aspect of our legislation that seeks to regulate the enforcement of penalty on employee, union, or employer for violating the rights or privileges of the other party, has its roots in the British law. Articles enshrined in the Nigerian labor laws compel employers of labor to fulfill their obligations to the employee, and also provides the legal framework that provides the appropriate punishment of offenders and compensation for the victim. Objectives of study session. At the end of this session, the student should be able to define what is law and trace the origin and evolution of Nigerian labor law. Be able to describe and explain the sources of Nigerian labor law. What is law? Law can be defined from a number of perspectives, but from a holistic point of view, law is a set of rules that have been formulated in an agreed way and manner to regulate a defined act, conduct, or omission with penal or administrative or civil sanctions in the event of breach or violation of the rules. According to Davis and Freeland, 1983, labor laws are designed chiefly to regulate, suppress, and to restrain the power of management and the power of organized labor. Brief history of Nigerian labor law. The history of contemporary Nigerian labor law dates back to the days of British colonial rule, when the country was governed as an appendage of Britain, starting from the 1860s until the independence in 1960. The earliest labor legislation enacted for Nigeria by the colonial masters was the Master and Servant Ordinance, number 16 of 1917. This law was limited because it covered only a certain category of workers, while others were excluded. By 1938, the Trade Union Ordinance, a legislation that seeks to regulate the activities of trade unions, was enacted by the colonialists. TUO has been roundly condemned in recent reviews because of the perception that the legislation was aimed primarily at keeping the various labor unions in the country in subjection to the state. Another class of players that have contributed to the evolution of labor laws in Nigeria since independence is the military. It is argued that more legislations on labor laws were enacted during the era of military regimes than at any other point in the history of the country, a situation that is generally believed to be responsible for the inherent draconian flavor of a large portion of Nigerian labor law. This situation is believed by many to be responsible for the mismatch between labor legislations and contemporary workplace realities in the country. Consequently, it has been argued that our labor laws, rather than being progressive, has remained static, rendering it irrelevant to modern workplace challenges. Sources of Nigerian labor law. According to the mainstream legal scholarship, Nigerian labor laws originate from two sources. 1. Statutes, common law or case law. Statutes refer to legislations made by Parliament which are deemed to be acts of the National Assembly. It also includes decrees imposed on the people during the era of military regimes, as well as what obtained in England as at January 1st, 1900. It seems that only the National Assembly is vested with the power to make laws related to labor matters in Nigeria. Section 4. Subsection 3 of the Constitution provides that the National Assembly has exclusive power to make laws for the peace, order, and good government of the Federation or any part thereof with respect to matters included in the exclusive legislative list set out in Part 1 of the Second Schedule of the Constitution. Item 34 of the Second Schedule contains the following matter: labor, including trade unions, industrial relations, conditions, safety, and welfare of labor, industrial disputes, prescribing a national minimum wage for the Federation or any part thereof, and industrial arbitrations. Item 44 of the Second Schedule contains the following matter: pensions, gratuities, and other allied benefits payable out of the Consolidated Revenue Fund or any other public funds of the Federation, common law, or case law. This makes specific reference to the body of rules formulated by courts which over time can serve as binding precedent for subsequent related cases. In this matter, the status of the court that made the pronouncement goes a long way in determining the weight or respect accorded to the decisions. Case law has more relevance and significance where it can be shown that there are lacunae in the statutes on a particular subject: employment of women and young persons as manual or clerical workers. Labor Act of the Constitution of the Federation stipulates certain regulations concerning the employment of women and young persons. These regulations include the following: 1. Generally, a woman cannot work on night duty. This provision excludes women, nurses, and persons in agricultural undertakings who are engaged in manual labor. Women can do night work where unplanned interruptions necessitate their engagement in night duty, or where the work makes use of raw materials that may perish fast. 2. No woman can be employed in an underground work in any mine unless she is doing a study which requires such work or occasionally enters the underground parts of a mine for non-manual work. 3. A woman is entitled to be absent from work for a cumulative period of 12 weeks, divided into 6 weeks before a confinement and 6 weeks after, subject to the provision of a medical certificate to that effect. 4. During this period, she is entitled to 50% of her wages, regardless of her absence, and cannot be issued with notice of dismissal. Furthermore, a woman is entitled to 30 minutes twice a day to nurse her baby during working hours. Concerning employment of young persons, the Labor Act provides as follows: according to Section 60, no young person shall be employed during the night, but young individuals above the age of 16 years may be employed at night. In the manufacturing of iron and steel, glassworks, manufacture of paper, raw sugar, gold mining, production work. Section 59 makes the following provisions amongst others: A. No person under the age of 16 can be employed to work underground, on machine work, or on public holiday. A young person under the age of 14 can only be employed on a daily wage and day-to-day basis provided he or she returns each night to the place of residence of his parents or guardian. B. A child cannot be employed to lift, carry, or move anything so heavy as to be likely to injure his physical development. Redundancy. The term redundancy, as contained in the Labor Act, is defined as an involuntary and permanent loss of employment caused by an excess of manpower. Factors that can lead to excess of manpower include technological advancement, low production precipitated by economic downturn, or negative medical condition. Conditions for valid redundancy: excess of manpower, An employee's contract cannot be terminated on the grounds of redundancy unless there is excess of manpower. Complete cessation of business or intention to cease to carry on business cannot lead to redundancy, going by the provision of the Labour Act. Consultation of trade union. Another condition is that the employer is under obligation to inform the trade union or workers' representatives of the reasons and the extent of the redundancy. Any such consultation must take place early enough for it to be meaningful. Principle of last in, first out. In the event of redundancy, the principle of last in, first out, LIFO, stipulates that the most recently employed workers shall be required to leave the organization, while the most senior workers shall be retained as members subject to their skills, abilities, and reliability. While skills and abilities can be empirical, demonstrated, and measured, there are concerns, however, that the subjective nature of how to measure reliability creates opportunity for favoritism. Negotiation of redundancy benefits. The Minister of Employment, Labour and Productivity is empowered to make regulations providing generally or in particular cases for the compulsory payment of redundancy allowances to workers affected by a declaration of redundancy. Labour or industrial disputes. Section 20, subsection 1c enjoins the employer to use his best endeavors to negotiate redundancy payments to any disengaged employee who are not protected by the ministerial regulation. It is clear that the spirit of the section puts the employee at a disadvantage because, take two, it is clear that the spirit of this section puts the employee at a disadvantage because they are left unprotected and at the mercy of the employer, especially in non-unionized workplace. Within the organizational context, disputes are often as a result of disagreements among employees and between workers' union and management. However, while disputes between trade union and management are common and enjoy front-page headlines, there are instances where the dispute is between two or more trade unions. The Nigerian law recognizes industrial disputes by different nomenclature. Trade disputes refers disputes between management and employees or among workers which is linked with employment or non-employment or the terms of employment and physical conditions of work. The various forms of disputes have specific characteristics and legal implications for resolving them when they occur. Intra-union disputes. In most cases, intra-union disputes have their origin from the organization and perceived violations of the running of the union, take two, and perceived violations in the running of the union as enshrined in the union constitution. Political, religious, or other affiliations and the propriety of such affinity, as well as discontents arising from election into union offices, come under intra-union disputes. Jurisdiction in intra-union disputes should be given to National Industrial Court to promote consistent jurisprudence on industrial relations matters. Inter-union disputes. Disputes arising from changes that are as a result of the restructuring of trade unions are known as inter-union disputes. It may include disputes concerning the proper union that can unionize certain categories of workers. Jurisdiction in inter-union disputes is conferred on industrial arbitration courts. Summary of study session. In this study session, we learned what law is and traced the origin and evolution of Nigerian labor law. We also described the sources of Nigerian labor law. This is the end of study session 2. Thank you.